Now the health warning. If you have not cancelled your contract, you should not read this presentation or continue with this video. We are not legal professionals and you should not place reliance on it. This is for information purposes only and should not be construed as legal nor financial advice. Hi, my name is Carl O'Daly. I'm the Director of KOD Lean Enterprises. Welcome to your free presentation. If you want to know more information about me, please visit my website, notjustthenumber.ie. Why we made this presentation. We know that a great many of you live in hope that this will solve all your problems. As we've stated on our website, the directive was badly misunderstood, which is why we decided to create this free presentation to you so that you'll be better able informed as to what you actually have done by cancelling your contract. We did not want to be in a position to take your money, quash your hopes and dreams, and then argue with you as to why you were wrong. That would be unfair to you and would only make your financial predicament much worse. We want to be able to assist those who have cancelled their contract legitimately, and we use the information that you provide to best identify who those people are and who we think we can help. We're a small company, we don't have unlimited resources to give for free. This is why the detail is important in the questionnaire that you submit. For example, we have seen commentary on social media where someone stated they signed a contract in a pub, so the directive applies to them. Unfortunately, it's not as simple as that. There are 3 to 4 conditions to be able to use the directive and its applicability, and that person may have only satisfied one by signing a contract in a pub. The mission statements and goals of this presentation. The aim of this presentation is to provide information to those who have already cancelled their contract with their financial institution that would like to engage the services of KOD Lean Enterprises Limited. We do not give legal advice as we are not legal professionals. We cannot tell you or advise you to cancel your contract. If you need legal advice, we recommend that you see a solicitor. If you have not cancelled your contract, you should not read this presentation or continue with this video. We are not legal professionals and you should not place reliance on it. Who can avail of this directive and its Irish equivalent? The directive and its applicability is very badly misunderstood. First and foremost, the European Court of Justice has held per the legislation that you need to be a consumer, as it is after all a consumer protection directive. The consumer in the legislation is defined under Article 2 as a consumer means a natural person who in transactions covered by this directive is acting for purposes which can be regarded as outside his trade or profession. This means it applies to natural living human beings. It does not apply to the body corporate or simply companies. Therefore, it does not apply to companies who obtained commercial loans involving trades as they are not people. A company has a separate legal personality, it is not a person. Okay, so now you know what a consumer is. Let's have a look at consumers and buy-to-let properties. This again can be extremely confusing as there's no straightforward answer to this. The financial institution may argue that you are not a consumer if the purpose of the contract was to acquire an investment property via a buy-to-let loan. Irish courts have been inconsistent in their treatment of whether someone who enters property investment is a consumer or not. This has come up on a couple of occasions in cases involving the legal effects of non-compliance with the Central Bank's code in various repossession proceedings. In Ulster Bank Ireland Limited versus Healy, Judge Barrett accepted that the investment was for personal consumption, so leave to defend against the summary summons was granted. In the Healy case, the judge looked at the scale of the borrowings and the number of properties acquired by the consumer to see if he was really a professional investor. The decision was later upheld by Judge Baker in Ryan versus Danske Bank. In another case, in ACC Bank versus Quinn, Judge White was more concerned that the paperwork stated the loans were commercial in nature, so did not accept the respondent's argument they were consumer, and therefore application of the legal protections of the CCM were relevant to the proceedings. You should take the opportunity to review paragraphs 27 and 35 of that case and see if they apply to your own circumstances. However, the good news, on a European level, the European Court of Justice has held in the prominent cases of Schulte and Krasheimer Volksbank that although the properties were bought by natural persons for the purpose of rental investments, they were nevertheless covered by the directive. In fact, it was not even questioned in these cases that the people were not even consumers. Now, if there's any doubt whether you're a consumer or not, there is an obligation on the Irish courts to refer the question to the European Court of Justice for answers. And as you can see, you have a definition of what a consumer is, and that consumer definition has been tested regarding buy-to-let properties in at least 2 to 3 cases. Circumstances under which you can cancel your contract. These can be found in Article 1 and Article 5 of the Directive. Article 1. This directive shall apply to contracts under which a trader supplies goods or services to a consumer which are concluded during an excursion organised by the trader away from his business premises or during a visit by that trader, firstly to the consumer's home or to that of another consumer, to the consumer's place of work, where the visit does not take place at the express request of the consumer. Circumstances under which you can cancel your contract. This is Article 5. The consumer shall have the right to renounce the effects of this undertaking by sending notice within a period of not less than 7 days from the receipt of the consumer of the notice referred to in Article 4, in accordance with the procedure laid down by national law. It shall be sufficient if the notice is dispatched before the end of such a period. Subparagraph 2. The giving of the notice shall have the effect of releasing the consumer from any obligations under the cancelled contract. What the European Court of Justice stated this means. Did you enter a contract with a financial institution when they somehow initiated a conversation with you or engaged you, whereby you eventually signed a contract based on an offer or a contract given to you, and crucially, you never met them in their office or business premises? That's a simple explanation of all those conditions. Within the terms of that contract, you were then subsequently never afforded a 7-day cooling off period or cancellation period. The directive applies once they started the ball rolling. You never went into their premises and you never got the 7-day cancellation notice. As a warning here, when you interacted with a broker, you need to be very detailed in your submission to us. People think there are 3 parts or conditions, but really there is 4. Based on the information that you provide, we will identify the 4th one. Okay, so you might be still confused. So I'm going to give you 2 simple examples. This is example 1. At this stage, I need to reiterate the fact that you made a decision to buy a property is irrelevant. In some correspondence I've seen, the banks are stating that you chose the property so it doesn't apply. That's not what this is about. You could have gone to a local bank branch, for example, to inquire about a mortgage. In that case, if you subsequently signed up with the bank and draw down the mortgage, in that case, the directive wouldn't apply. But say, for example, an eagle-eyed broker saw you coming out of the bank, stops you on the street and tells you, don't sign with them, I can give you a much better competitor offer. I can get you more money at a cheaper rate. He's so eager to come see you, he arranges to meet you the next day. He travels out to your place of work, travels out to your home. You eventually draw down the mortgage. In this case, you would be entitled to cancel your contract. Whilst you made a decision to buy a house, that's not relevant. It's the broker's sales technique which is at issue, and not your decision to buy a particular house. Okay, this is the second example. So think back to the Celtic Tiger era days. A clear example of this was when you went out to see a new housing development. You see your dream house and you want to buy it. Say, for example, Alpha Bank were financing it with the developer. Alpha Bank might have had a sales team on site conveniently for you to be able to see if you could borrow money, fill in an application. Oh, you like the house? Come see us here. Here we are. And you know what, even better, here we are on site. We know the house. We know exactly what it is. They said they can give you a competitor offer, and it does turn out to be the best offer. So you sign up with the paperwork. In this case, Alpha Bank have organised an excursion, not on their business premises, so you could potentially cancel your contract. In fact, anyone who met Alpha Bank in those circumstances could possibly cancel their contract. That is a lot of people. Are you too late to cancel your contract now, years after the event? The European Court of Justice has stated no. There's no temporal time limit on this if you've never been given the opportunity and the right in the first place. They've determined that the onus and responsibility relies with the financial institution to abide by the legislation. See Schultz at paragraph 103. They are also, and this is crucial too, they are also responsible for the conduct of the brokers. So if the broker introduced them to you and the broker didn't do things by the book, they are still responsible for his conduct. And here's the thing. If the house is now negative equity and there's a shortfall, that's their problem, it's not yours. Okay, these are the next steps. If you've already cancelled your contract and you would like for us to have a review of your documentations and your reasons why, please send them in to us using the contact form. So you've cancelled your contract, but you may not know why. After this presentation, you'll have a better reasons of the entitlements to cancel your contract or not. If having reviewed those entitlements, you feel that you have a case to answer, please submit your details to us and we will review them free of charge. We will only review submissions received online, so please make your answers as detailed and comprehensive as possible, as the information we'll use for our analysis is what you give us. If we feel that you are entitled to cancel your contract, we will contact you to offer our services to help you vindicate your rights. If we feel that you had no entitlement to cancel your contract, we will let you know. However, if you wish to have a one-to-one meeting with ourselves, please know that there will be charges for that session. Finally, we are here to help you. We're best able to help you by you giving us complete and accurate information.